Madam Chair, Commissioner Abdab, Resource Development Committee. This particular legislation is the a settlement for the Little Colorado River Basin Corridor. This particular settlement has been in discussion for a number of years. Our staff have been working on it and meeting with other parties that are involved in the Little Colorado River Basin. Now to this day, they have brought it back to us. They told us that parties have reached an understanding, an agreement, and all needs thing required is for the Navajo Nation to agree to the settlement, and then also to the Hopi tribe to agree to the settlement. This particular settlement, as I stated earlier, that it is my responsibility to bring this before the council, the committee, the council, and that we all need to make a decision. And we need to also debate on the issue, and some of us and some of the members have already made a decision, and some are not. As you could say, maybe there's some of them are still sitting on the fence, or maybe they need more education. Or there's just about basically every situation involved when you're about to discuss the most critical legislation. As I served many years on the council, many times such a legislation has come before, and I had a chance to make a decision on it, and by the decision I made, I was thought of the people. Did everything I could to do my homework, what I would feel is best for my people. I thought without to this day I'm enjoying my position I hold in serving my people. Without it, I just so at this time, I want us to make a decision on it, and I know that it's going to go before the Navajo-Hopi, and it needs to go before the council. I appreciate your debate, and I appreciate your decision. Yeah, Madam Chair.
Thank you, Madam Chair, and good afternoon, Mr. Speaker. Let's say we approve this. One of the worries I have is that Senator Kyle and others might misconstrue it as an authorization to move Senate Bill 2109 forward. The Council, I think, has spoken clearly on 2109, saying that they don't want that type of legislation. Has your office, or are you aware that the President has communicated with Senator Kyle or the sponsor of the House bill that 2109 will be changed or will be thrown in the trash? Because there's no way to move this forward even if we approve it in the absence of a legislation. And so how is that going? how is this going to work? And considering the short time, and considering that this supposedly has to go through Senator Kyle, who is now being deemed to be the champion of Indian water rights, right or wrong. It was interesting to read the Navajo Times article of a gentleman that visit, and some award was being given to Senator Kyle. And to say that then they threw him out. The only Indian that showed up for his festivity got thrown out. And he was being recognized for supposedly being a champion for Indian water rights. But my worry is that I think if we approve this, then it will go forward on 2109. And I think maybe the better thing to do is not let it move forward until some assurance is given back to Navajo Nation. That there be a different process used or a different legislation. So because they're trying to connect the 2109 to the settlement. The other one too, Madam Chair and members of the committee, the Navajo-Hopi has spoken, and so on this CG, because the Navajo-Hopi has spoken on the legislation, and the legislation attempted to include this, do we have a conflict here now in trying to move this forward? I understand that the Hopi Council has also deliberated on the settlement itself and has passed it on a tie vote with the chairman of the committee passing the yes vote. So I think it was an 8-7. And then there are a lot of questions in the legislative settlement itself. I did hear the president's staff. I don't know why they're not here, but if they really do care about the passage of this, they should be here. Because last night I heard him on KTNN, even accusing people up there speaking against this of deception. I wanted to ask them on that, where they've seen such deception. So the other concern I have too is I think, I don't know if Mr. Pollack is coming, and if he's not going to be here, then I think he's the main one that, along with Ms. Hoover. I don't know how we're going to address that, Madam Chair, that the main lawyers that worked on the agreement are also not here. So we can't get any answers on some of these words, unless, of course, the speaker wants to, I guess, answer on the agreement itself, and we can ask them on it. But if that is the case and they're not going to be here, maybe the better option is to table it and tell they show up or otherwise. Thank you, Madam Chair.
Yeah, Madam Chair, the members of the committee. Going to Mr. Sosa's question about Senate Bill 2109. The Senate Bill 2109, Senator Kyle's bill. The not yet the pass or rather oppose 2109. However, that Senator Kyle, the bill, what we done, will let him know that the Navigation Council has opposed that bill. But this settlement, we've done what we can. Debe cada día bajar dando so we have to take an action on this settlement and let them know where we stand on this settlement. So the question that's before you is the settlement. We have several sessions in regards to the settlement. Mr. Howard and Katie, they were at BNF. Although Mr. AG is here also, probably throw some questions at him or refer some questions to him. Mr. Sosabel, Madam Chair. So, we wish to do with this settlement. Maybe yes.
Well, give us the details of the settlement. That's what we're asking.
Okay. I'd like to put this in context so you understand exactly what's going on. We started litigation, we joined litigation in 1979, a general stream adjudication on the Little Colorado River. And what a general stream adjudication means is that by law, in a certain state, like the state of Arizona or Utah, New Mexico, whatever state, they will identify a river basin. And all of the waters that flow into that river are adjudicated under a general stream adjudication. Everybody that lives within that basin comes forward when a general stream adjudication starts, and they file their claims. In our case, this stream comes out of the White Mountains. The river does. That's the headwaters, the snow melt and the rain. That it all gathers and drains into the river and starts flowing through the off-reservation portion and through the Navajo Nation. Now, in this process of general stream adjudication, everybody that lives within that basin that has a claim or that uses that water comes forth and says, look, I use X amount of, let's say some farmer says, I have 100 acres under irrigation from this river source. Or else they collectively will group together as a water users company, a ditch company. The city of Winslow will come forward, St. John's, Holbrook, Flagstaff. All of the water users file a claim in the court when there's a general stream adjudication. The Navajo Nations responded. Somebody filed a claim to adjudicate the river, Phillips Dodge. So we had to respond and protect our rights back in 1979. So from that day forward, there has been a lot of litigation. Motions have been filed. We tried to get it out of state court back into federal court. We lost those cases and ended up getting pushed back to the state court. So there's a lot of work that has gone and taken place in court. For 33 years, we've been litigating this particular matter. And I said, we've lost some issues and we've won some issues. But during those 33 years, we have, by the briefs we've filed, by the motions we've filed, have to a certain extent convinced the parties that are involved in this general stream adjudication that we have valid claims based on certain legal doctrines. The historic use doctrine, the aboriginal rights doctrine, the Winters doctrine. Those are the basis of our claims. We say based on these legal doctrines, the Navajo Nation has rights or has claims to this amount of water. We haven't turned them into rights. This is the process that you go through to take your water claims and turn them into rights. You don't have rights until you go through this general stream adjudication and a court issues a decree. Once a court issues a decree, then you will have a right to use a certain quantity of water. Now, we've been going through that process for 33 years. And I said, we've relied on various legal doctrines. We've brought in a lot of experts. We've brought in hydrologists, water engineers, historians, and it has cost the Navajo Nation an enormous amount of money to get to this point. Now, today, we are faced with the option. We have two choices, only two. The choice is we continue with litigation that we've been involved with for 33 years, or we settle this case. Those are two choices that we're confronted with. If we continue to litigate, what will happen is we will spend more money on attorneys, we will spend more money on experts, and we will spend more time in court filing claims and filing briefs and motions trying to end this case. At the end of the day, the option is that a state court judge who will be non-Navajo will tell all the litigants that this is the amount of water you're entitled to, this is the amount of water you're entitled to. There are over 3,100 people in this litigation, or entities. When the state court judge enters that decree, if that's the choice that we take, we are advising the Navajo Nation that it's unlikely that we will get a favorable result if we proceed down that path. We will get some results, but we don't know what kind of results. There's uncertainty. So we chose to say, let's get together as parties and try to draft up a negotiation or an agreement. And the parties that are involved in this litigation, rather than having the judge make the ultimate determination, determined that they could settle the case amongst themselves. And in that negotiation process, not one party gets everything they want. There's compromises. Everybody has to compromise. And that's what took place in this negotiations. There was compromises with all the parties involved. The big parties are the Navajo Nation, the Hopi tribe, the state of Arizona, the federal government, and then all of the other water users that have claims in this river basin. And the result is the settlement agreement that's before you. And as I said, the Navajo Nation did not get everything it wanted, but we fought hard for it. And there was compromises in here. And what the settlement agreement contains, number one, is it addresses the surface waters that flow into the Little Colorado River drainage, into the river. And the indications are, based on scientific data and people that we trust to be accurate, they've determined that the annual flow of the Little Colorado is 220,000 acre-feet per year. And it's also acknowledged that people that live up at the headwaters of the Little Colorado River in the White Mountains and as it flows towards the reservation, they have established uses, and they have filed claims also. And the agreement says and acknowledges that out of the 220,000 acre feet, the state of Arizona, for their benefit, will get to manage 60,000 acre feet of that float. The remainder, the 160,000, the Navajo Nation will get to use. So that's what the surface water addresses. And the difficulty with this particular stream is at the headwaters, it flows on the surface. As it comes towards the reservation, the geography changes, and you mostly have sand, and it kind of disappears into the sand. And that's why, from our end, it's very difficult to capture this water, but it does go beneath the surface of the earth. So we also, in this settlement agreement, address the aquifers, the groundwater. Number two, it addresses the sea aquifer. And our use of the sea aquifer beneath the Navajo Nation is unlimited. And based on engineers, hydrologists, the claim is there's 4,018,000 acre feet of water in the sea aquifer. On the Navajo Nation, the sea aquifer pretty much belie the entire Navajo Nation, most of the Navajo Nation. And we have unlimited use of the sea aquifer. In addition, on the southern boundary of the reservation, we have buffer zones where the reservation boundary is. We have the first buffer zone that's 2 miles out, and we limit the amount of wells that can be drilled there. And we have told the people outside of the reservation that they can't drill there, new wells. But some of the existing wells are grandfathered in. Then we extend the buffer zone a little further out, and we have certain limitations there. That they can't drill new wells that pump more than 500 gallons per minute. And then we have a third buffer zone around the loop area, because that's the area where we intend to drill at least 20 deep wells into the sea aquifer to take that water into a pipeline from Loop, Dilcon, and eastward. So that's the sea aquifer component. Then you have the in-aquifer component. If you look at the layers of the earth, the sea aquifer is very deep. At a certain depth, there's different aquifers, different layers of rock, and the water is within the pores of this sandstone. And the Navajo aquifer is also included in there. It lies under a large portion of the Navajo Nation and the Hopi Reservation. And this water is pristine drinking water, very good quality water. So in this settlement agreement, the agreement provides for the Navajo aquifer will be managed primarily for domestic uses, mostly drinking water. And we agreed with the Hopis that it would be managed, and it's unlimited for domestic uses, for household uses, for hospitals. But we limit the amount of industrial uses that can be applied to 2,000 acre feet per year from the in-aquifer. And some people today claim that it's being depleted by Peabody and so forth. The scientific information that we have is that is not the case. And as a matter of fact, Peabody is going through the process of turning over its wells back to the Navajo Nation. And some of those wells are going to be used for the Mini Deals project that was recently funded by the Navajo Nation Council. So that's the third component. And on the in-aquifer, there's the unconfined area, which is a larger area, but then there's a confined area. And in that area, there's a hard layer of rock above the in-aquifer, and it applies pressure. So that water is under pressure. And in most cases, when you put water under pressure, it's easier to bring to the surface. So there are certain limitations, and that's the limitations I'm talking about. Only 2,000 acre-feet for industrial uses. The third thing that we address, or the fourth item we address in this settlement agreement, is the washes that flow across the Navajo Nation. They flow through the Hopi and back into the riverbed. We've identified 5 primary washes. And we address those, and what we've said is, when the waters come out of the Navajo Nation and flow towards Hopi, we can't build new impoundments other than what already exists there. And once it reaches the Hopi reservation and they flow through the washes through the Hopi reservation, the Hopi, we've also limited their impoundments. They can't build new impoundments there. But they can use those washes in the historical manner that they've always used them. So you have it coming from the Navajo Nation to Hopi, that flows through Hopi, and then it goes back again through the Navajo Nation. Once it comes back through the Navajo Nation, then we can do with it what we like before it gets into the riverbed. We just can't build new impoundments above the Hopi reservation. So that's the agreement we have on the washes that flow from Black Mesa down across Hopi and into the riverbed. The other last thing, as a component of this settlement agreement, we wanted dollars. And we've convinced the federal government to provide dollars for certain projects. And they wouldn't provide dollars if in the compromise we didn't agree that the non-Indians could have something. Remember I said that they have 60,000 acres that they're currently using and have been using historically. The other thing that I hear a lot of is people saying, we have winter's rights. Those really aren't rights. It's a law. It's a legal doctrine that you can take to court to say, I'm basing my claims on this legal doctrine. So there's a misperception that we actually have rights. We don't have rights yet. We're in the process of trying to quantify our water rights. And that will not happen until the judge decrees that the Navajo Nation has this amount of water for its use. So that's the process we're going through. So the dollars that I'm talking about, one of the parties I mentioned in this litigation is the federal government. Part of their agreement in this settlement is that they would provide a certain amount of millions of dollars to fund 3 projects. 2 of them for Navajo and 1 for Hopi. And one of those pipeline projects runs from the Loop area eastward, over by Whitecomb, I believe, through Dilcomb. And it has a certain capacity, over 4,000 acre-feet of water per year. That's the capacity of the pipeline. The federal government's obligations would be just to build a trunk line, just the main line that comes through there. The distribution systems off of the trunk line would be the responsibility of IHS, NTUA, or whoever. So we would still have the responsibility to have IHS do the distribution lines off the main trunk line. The other project for Navajo is from Steamboats to Ganado, southwards to Clagato, and I believe it's the Wide Ruins. That's the second project, pipeline, that they would build for the Navajo Nation. And it would also have a certain capacity, and their responsibility would be to drill wells, to supply that pipeline, and to deliver water through this system. And then there's a Hopi groundwater project also that's included for them, and the federal government is agreeing to fund that. Now, the last thing that I've heard that a lot of people are maybe taking issue with, or so they're saying, look, we're waiving rights. Number one, I explained to you that we don't have rights yet. We have claims, and we will not have rights until we go through this adjudication process. That's the process you go through to obtain water rights. Every claimant has to go through the same process. And that's what we're involved in. And we've been involved in that for 33 years. And we've come to this point where we've drafted up a settlement agreement amongst the parties. And it's this council's opportunity to say whether they agree with the settlement agreement or we continue litigating. Which one is it? And the other option is, not the option, when you elect to do a settlement agreement, it's standard practice in litigation to say, to waive any further claims based on the facts and circumstances of that litigation. So anytime you go to court and you settle, both parties or all of the parties say, okay, we're going to settle this litigation, it's going to be done and over with. From this day forward, I will not bring any additional claims based on the facts and circumstances that we're now settling. That's standard litigation practice. And those are included in this settlement agreement. And many people say we're waiving something there. What we're waiving is that we won't come back and try to resurrect this litigation. That's what the waivers are. So that's the primary content of this settlement agreement. And as I said, one of the parties to this litigation is the state of Arizona, the Hopi tribe, the Navajo Nation, all of the cities. Every party has to take this settlement agreement back to their authorized representatives. In our case, it's the Navajo Nation Council and the President. In the case of the Hopi tribe, it's their council. In the case of the state of Arizona, it's their legislative body and the governor. In the case of the United States, it's the U.S. Congress and the U.S. President. Every one of these parties has to settle it. The Speaker has drafted up legislation right here before you for the Navajo Nation Council to approve the settlement agreement. The federal government is doing the exact same thing. Senator Kyle has drafted up Senate Bill 2109 for the federal government to approve the settlement agreement. And on their part, they have some other responsibilities like providing dollars for these projects. And because of that, they do some legislations, drafted up an agreement, and they're agreeing to pay millions of dollars for the projects that are included in the settlement agreement. Now, in Senate Bill 2109, they also gave the Navajo Nation an option. We can take the option, just like we can take the settlement agreement, or we can reject it. And that option is to get water into the Window Rock area and Fort Defiance area sooner under a separate law. The settlement agreement in the San Juan River Basin in New Mexico provides the Navajo Nation can get cap water into Window Rock and Fort Defiance on two conditions. The first condition is that we have to have a settlement of the lower Little Colorado, or the lower Colorado River, the main stem. And we thought we would have that because the council back in 2010 approved that, and it was rejected by the federal government. Included in that, the second component is that we also have a settlement on the Little Colorado River. And as I said, both of those were done back in 2010, and we took it to Congress. The last council approved those two settlement agreements. But the determination by the federal government, because they were in dire economic conditions back then, they said the price tag is too high. Can you trim it down a little? So we excluded the lower Colorado River portion of the agreement and just carried forth with the Little Colorado River settlement. So this deal is pretty much the same deal. But, as I said, in order to get water to Window Rock and Fort Defiance and some of these areas here through the Navajo-Gallup pipeline, we were supposed to meet two criteria: settlement of the lower Colorado River and the Little Colorado River. Now, to appease us, they said, we will allow you to get water into Window Rock and into Fort Defiance through the Navajo-Gallup pipeline. We'll do away with having to settle the lower Colorado River, and you only need to do the Little Colorado River. But they added something else. They said, we also want something. Remember, this is a compromise. This is negotiations. And they said, we want the Navajo generating station to continue operating until 2044. And we looked at this provision and thought about this. And under the existing lease with the Navajo generating station, they realistically have a right to operate until 2044 anyways. Because the initial lease runs for 50 years, and the owners have a right to extend that from 2019 to 2044. It's their right. They have the call. So we figured, well, it's probably going to operate until 2044 anyways, because we have already agreed to that in 1969 when the Navajo Nation Council approved the lease for the Salt River project, Navajo generating station. So that's why this option is included in there, and we figured that NGS is going to continue to operate anyways because it's already in their lease agreement. We've already agreed to that. So that's what the option is. And as I said, we can reject it or we can agree to it. In my opinion, even if we take the option, for the most part, because we have existing legal obligations to allow it to continue to 2044, it really doesn't harm us. And so that's the option provision. Then there are other provisions about providing additional funding. So the Western Pipeline that was under the lower Colorado River settlement can be studied some more and some initial designing done. It also reserves some cap water for the Navajo Nation for future water settlements. So that's what's included in the settlement agreement, and that's what you will be approving. So you have the option of saying, we're going to end litigation today and take what is a sure deal as spelled out in the settlement agreement, or we'll reject the settlement agreement and continue litigating. That's the option. That's my report.
Madam Chair, members of the committee, the speaker, sounded real good until you got to number 5. This is where the federal government starts to get me. get involved. You mentioned that the U.S. provides the dollars for water facilities. But we don't know how much we're willing to put up for. If that's the case, then anytime we've ever done business with Uncle Sam, the promise thing is always falling short on the government level. So that's one issue. And coming up with a comfort level and what will impact our nation in the future. The second thing is the bill itself, 2109. Earlier there was a question about the validity of this initiative. That would the bill give authorization if it needed to substitute? Mention that. And so my question is, what is the relationship between congressional action to this settlement that is being determined here? And when you come to your waivers, it mainly applies to language, two terms that you use. One is rights. Rights we don't have. But claims we do. We can make claims to it. And so in the language is that waiving our right to claim, reversing it, and utilizing claims itself as the main initiative. So when you waive claims, does that mean that whatever the outcome of the situation will be, we have no more, we can't claim any water at that point. And so that's issue in the language itself. When it comes to water to the mineral, has those waters already been quantified? And so the nature of its use, we have a responsibility for that. So the water's been quantified. And the option of rejecting or accepting this settlement. These are my questions, Madam Chair.
Thank you, Madam Chair. And you mentioned the water beginning point is in the White Mountains. After it begins, are there any dams or reservoirs now that along the tributaries for the Lower Colorado River? And if there are, how much water are they holding back before it reaches the Navajo Nation boundary line? And who's holding it back? The second is, has the legal team representing the Navajo Nation investigated whether Senator Kyle has an interest in any of these water rights along the tributaries of LCR? It's my understanding that he does have some holdings, and I'm wondering if this has ever been investigated to see if there is. In the agreement on page, by the way, we don't have the whole copy of the agreement. It goes to 100, it's supposed to go to 100, but we only have it up to about page 82, the one that we have. So, because I want the NGS provisions are at the page 94. But if you look at the, on page 21, there are priority dates, it appears to have been given. And if you look at the water right court decisions and other things, I thought the understanding is that a priority date, at least from a federal law perspective, is that at the date of the creation of the reservation, Indian reservation. And why are we agreeing to a later priority date? For example, if you look at Luke Farms, we're agreeing to a priority date of 1901. And so from 1868 to 1901, we've lost over 40 years. And if you go with the earlier treaty, then it should be much more. And you look at the creation of the town or the incorporation of the towns in these, like Snowflakes and others, you know, they're around those times. And so we should be claiming priority dates of 1868 and not 1901. It's at the time that the Navajo Nation, or the original boundaries. The other interesting thing too is, I don't know, I wish we had a copy of the Navajo Nation response in the litigation when we first entered in 1979. Because it would be interesting on what we were claiming at that time as part of our response. And so we could then compare it with what we're giving up and what we're gaining. And that not being the case, I don't have that before me. But it would be interesting to see that, because you make the notion, and by the way, I respectfully disagree. If you don't have a right, then you don't belong in court. You're saying that you have a right to something, and you're trying to protect that interest. And so, and that's why you're in court in the first place. And the process that is used to assert that right is the claim, a water rights claim. And we're saying we have a claim to a certain amount of water and that we are entitled to this. And so I think as our chief legal officer saying that we don't have a right, it kind of troubles me. And I disagree. We do have a right to these waters, and what I'm leading to is the Aboriginal right. And if we have Aboriginal rights to these things, we've pre-existed the United States. We've pre-existed the state of Arizona. And we've pre-existed all those towns there. We are subscribing to their notion of so-called civilization. I don't know how they define civilization, because I think anybody who develops a drone missile is not civilized. You know, because you're tearing up humankind by doing that. Especially when you're not doing it in defense. But nonetheless, though, they have their definition of civilization, and we subscribe to that. See, right off the back on up to page 21, you see these other things. In essence, you know, it appears that when we go to litigation, we are going to still get the water that is flowing onto the res and make use of it. I noticed that the Water Rights Commission and also the President's Office and also in the ads, they were talking about the headwaters. But if you read this, you know, all this agreement only limits us to Navajo Nation land. And we then explicitly say that we are not going to reach beyond Navajo Nation land, even for impoundment. And so why is it that then we're telling Navajo people that you're lying, that you're defrauding, you're deceiving? The actual agreement does only limit us to the boundary in terms of our authority. So that leads me to the question, if we don't have the authority to reach beyond the Navajo Nation boundary, then what is the process if somebody upstream has decided to use more water than they're allotted? And so what do? Go back to court again, state court? And considering 3,000 people being involved in this litigation, you know, that would be an endless thing. And then how is it that then we're going to monitor their use? I don't see anything about monitoring the actual use of this to some central reporting registry to make sure that the cities that are saying that they're going to use it, you know, use the share that they're allotted. Just to give you an example, I know I was at one of the meeting, and Hopi was objecting to Navajo Nation's call for a limited size pipe on their waters, on the land that they bought. They don't want to be restricted in the size of their well. And I know what they're wanting to do. They want to increase it from 4 inches to 12 inches because they want to trunk that line to Holbrook and Winslow and sell it. That's what they want to do. And so if Hopi is going to start using so much water and start piping it out and selling it, how do we monitor that? I don't see a scenario in here for monitoring the use of this. I know this is going to happen because Hickory is going to do it with Gallup. Hickory is selling it to Gallup. But at least that goes through Navajo Nation land, and so that we can see how much is flowing through there. But in this case, you know, all these activities are going to happen off the Navajo Nation land. And by this settlement, we're limited. We're limiting ourselves on the impoundment, on the enforcement, and other things. And the only thing we can do is go back to Arizona court, get on our knees, and beg them to issue an order. And so I don't see any penalty clauses when you catch them. You know, the cities and others and Hopis, if they go beyond their allocation. The specific provision, if you want to look at, is on page 20, where we limit ourselves. It says, the Navajo Nation shall have the right to impound on or off Navajo land any water supply that it has the right to use. Then it says, so long as such impoundment does not conflict within existing water rights. What does that mean? Nothing herein shall create any right of access or easement to impound waters on lands not owned by the Navajo Nation. So we can't even drive up there to see how much they're using. There's no easement. And so who do we trust on monitoring this whole situation? Arizona, in my perception, is somewhat leaning against Indian tribes on their use of water rights. You just see the CAP and you just see the negotiations. I could even go as far as to say that they don't care for Indians on its water rights use. And so they're going to do everything they can to limit. The other thing too is this one, we're incorporating Arizona cap water, Central Arizona Project water. Are we waiving the provision in the Colorado Compact when we do that? In the Colorado River Compact, it specifically says that nothing herein affects the obligation of the United States. So if we're incorporating Central Arizona Project water and limiting ourselves on the receipt of it, have we not renounced that provision in the Colorado Compact? That worries me too. And so, because at the outset, you know, we're saying that this doesn't affect the Colorado River, but because of by history and the way the Central Arizona Project was built and how it comes from Colorado River, I would venture to say that there is some concern on it. The other one too is the Navajo Nation versus Department of Interior. I believe we are agreeing to dismiss that case. And it is my understanding that the Navajo Nation versus Department of Interior, the claim in there is against the United States government for the lower Colorado River, the big river. And so if we dismiss Navajo Nation, whether it's by prejudice or not, with prejudice or not, we are still dismissing it. And even if it's without prejudice, who's going to be around in 10, 20 years to refile that claim if we find out that this agreement was not abided by? And I know I don't think I'm going to be here to monitor you. I'll be long gone, whether it's to heaven or otherwise. By the way, Mr. Speaker, I know I'm going to heaven. I don't know about you. So, but the point here, though, is that how are we going to, because these have just such 10, 20-year time span. And this is why setting up a monitoring effort is so important. So I think it's quite interesting. When I first became a delegate, I praised DOJ for an innovative way to come back in and claim water rights to the lower Colorado River. The very thing that I praised them on, now they're dismissing it. And so I think once we dismiss that, I think it's going to be very hard for us to get back in. So the other thing I wanted to ask too is, in all this document, the United States is being characterized as our trustee. It's supposed to be our big brother. And what has the United States done to help us with the Little Colorado River adjudication? From my perception, the United States has actually been an adverse party in this litigation. And they've done, it appears that they've done nothing. And so then if they've done nothing and if they behave themselves like that, how can you claim for them to be our trustee in the settlement? Because they've done nothing but frustrate our effort in this litigation rather than helping us. They should behave, the United States government should behave the way they did when they helped out the Tohono tribe, the Gila River tribe, when they adjudicated that claim. They were actually there threatening the state of Arizona that they have to agree to it. And that's why they got so much water down there. It was not because Gila River was so good or so smart. It was because Big Brother, the U.S. government, was there threatening the state of Arizona. In this case, that didn't happen. In this case, they're actually our adverse party. And then so in the settlement, we're treating them as trustees. So at the outset, maybe we should say that we don't trust the U.S. government as our trustee. And that we want the court to appoint the United Nations as our trustee to protect our rights. Maybe it should say that. Because the United States has done nothing but frustrate the Navajo Nation in the water rights fight. And they sure as darn are not acting as the trustee. And so here we are defending or dismissing the claim against them. And then I think it'll be interesting to see all the claims on the priority dates by other parties. What has the city of Snowflake claimed to be its priority date? And what has I see the Department of Transportation in here, Arizona Department of Transportation. What are they claiming as their priority date? And so I think it'll be good to see that. I think then, I can't read my scribbles here, but on the NGS, I fail to understand your rationale. Either you don't see it or you're so smart. It's one of the two, Mr. AG. If the NGS, we're not giving up anything with respect to that, the inclusion of that, then why is the state of Arizona and Senator Powell insisting on the inclusion of it? See, NGS is totally out of the Little Colorado River area, but they're including it. And so it's irrelevant to LCR adjudication. But the Navajo Department of Justice has allowed them to include it. I think from the outset, even in the agreement in principle that was produced, the Navajo Nation Department of Justice should have objected to it. Of course they're getting something. And that's why they've included it. But now we're saying by including this, we should get something in return. And so in your mind and in your, since you've been involved in these efforts, what has the Navajo Nation gained with the inclusion of NGS? If we've gained nothing, then why are we including it? And so what I think your words were that we're not going to be hurt by including NGS because we're already talking on it. With that, Coco, I think there is more than what you've described, in this case the buffer zone, the N aquifer, and the C aquifers. On the Hopi thing, how much water, I think it would be good to see how much water flows from the Navajo Nation into Hopi, and then at the moment or historically, and how much comes out Navajo Nation. So that, if all along we have been using more of the water that flows before Hopi, and then very little comes back out anyway, then I think we need to examine whether we're getting a fair treatment with the Hopi tribe. Because we're also looking at the existing water rights use. Navajo Nation's been using a lot. Then finally, Madam Chair and members of the committee, on the aquifers, can you document for us or tell us how much is the Navajo Nation using of the C aquifer at the moment? And then how much is Navajo Nation using of the N aquifer? And if it costs us so much and if we're not using anything, then what good is the right if we can't afford to tap into it? Then we're essentially giving up something or gaining nothing. And so I think, I don't understand why there's no, if the Congress is going to appropriate money, why can't we then ask Congress for more money to tap into the N aquifer and the C aquifer if we're going to have unlimited use of it? Because if there's no money for it, then we can't make use of the unlimited right because we have no money to tap into the aquifers anyway. Then it's like gaining nothing. And so why wasn't that addressed in the settlement talks? Thank you, Madam Chair.
Thank you, Madam Chair. One question in different direction as to associate measure concerning the existing lease NGS. My concern is with the relationship between this settlement and congressional activity. So the question is, why is NGS even included in the bill? And so, in your presentation, you mentioned about the extension of the lease to 2044. But from the congressional portion of it, why is it even included in the book, Madam Chair?
Thanks, Madam Chair. Go can members and presenter here. So let's just speak with all those are the audience. Yeah, 220,000 acre-feet per year. I question that figure. Was it taken in the during the high precipitation, or was it taken during the low precipitation? Yeah, on the Timor. You know what was about Timor. Or what how long was it studied? 10 years, 20 years, look at the average. To me, that 160,000 acre-feet per year, it's just an imaginary figure to me. It's just like a bait. And that's how popped up and you just jump it off. To me, according to the figure that's given to us, there should be 6.8 acre-feet per hour. It should be that's what they should be using before it gets into the reservation. When it gets into the reservation, we should be seeing 18 acre-feet per hour. Say then that's just an imaginary figure to me. They're giving us this figure as a bait. 160,000, no. Oh, yeah, you know, I see this thing. I disagree with that. What day? It should be already. I'll see. See for me. No general distinction. It was supposed all the way up to 2044. What is it you do? So crazy, because indeed, so did 160,000 you carry it on the water and you spill the water in the sand. You're supposed to deliver to somebody and say, oh, where's the water? I spilled it in the sand, take it out. No, I don't know, just case. I need to know, wait, what day? I just want to make the call. Yeah, Madam Chair.
Got to talk about the Latis. Was there ever a meeting with Navajo Latis regarding their water rights? And if there wasn't, why are we including them? This goes back to the United States government again as the trustee. If there was never a meeting to give information to the Latis so they could maybe give informed consent, and the United States government is not doing that, maybe we should call it as it is. That the United States is violating the legal rights and the human rights of Navajo Latis by signing off on a document without even informing them. Just call it as it is. If they've never done that. But if they did have a meeting, I'd like to know when they met with them. I know Latis are well organized. In New Mexico, they have a Navajo Latis Association. They also have Shishikeya. And there are allotments that I'm aware in Arizona. Has anybody ever made an attempt, whether a Navajo leader or a federal leader or a state leader, has anybody ever made an attempt to at least make contact with them and hold a meeting with them? I don't think you could use the general meetings as a reason to say you've informed them, because you don't know if Latis were there or not. And if you've never done that, you cannot include them in the settlement. They have to stay out of it because it's not an informed decision. You know, and so Again, going back to the United States as a trustee, we should say that they've been a bad trustee, and therefore, the court should appoint somebody else as a trustee to protect the rights of a lottee and Navajo Nation itself. And just to comment on Delegate Pete's comment, when Colorado River contract was done in 1922, they had certain data before them. Now they're finding out that they were wrong. At the time when they did the Colorado River was during the time of a higher precipitation. And that the normal part of Colorado River was what's going on today. And this led to Senator John McCain himself, when he was running for president, to reopen the Colorado River Compact talks. Because the whole thing was based on erroneous information in the Colorado River negotiation. So you do make mistakes if on these studies, and I think that's what Mr. Pete's question is also about. Are we relying on a data that's very reliable, or is this something that they're dangling in front of Navajo Nation just for us to agree to something? With what we know now, and the experts agreeing to it, that the Colorado River information in 1922, what they based their Colorado River Compact on, was erroneous. It was done at a time when it was high precipitation. And so that being the case now, that river is over-allocated. And by the over-allocation, they are affecting Indian water rights, including Navajo Nation. They're making use of the whole thing. And so it just leads you to what I guess the white man does, and say, yeah, we're not affecting Indian water rights, but we're going to suck it all up. And they've essentially done that, and they've left a trickle. And then you also look at Mexico's government objection to the Colorado River Compact. And it was because of their objection, then, because of the international law, they had to come back and address the Mexican government's objection. In our case, we object to it, and then, our so-called trustee just brushes it off. And the state of Arizona just brushes it off. Because all these people, the 3,000 and something, don't want Navajo Nation to gain one more inch, and I understand that, of water. And so they'll do everything to fight it, and they would rather see Navajo Nation perish. These other 3,000 want that. And so, they don't say it, but their action says that. So, Elena, thank you, Madam Chair.
Thank you, Madam Chair. Member RDC, sponsoring this legislation. Share opens this case for my thoughts and comments. Project care for Sahano for the change. He's only doing my hope. For 80 years, so I used to have it. I could end this. I shared and I thought, oh, yeah, it's that case. The urgent care for Sahano. I don't Canadian. Kuna the water. It was an hour of this. I think that one should be. So he is coming to Navajo-Hopi. His only shade out of the case for his. I don't hear up in it. The naturally, care for some even if you can't or and here something as a water some Aliago, she got the other, his Aliago country. But Oceania, according to country, according to should be Asher. Ako, di nasa nabishi, that's it. Pasanado, Facebook. There's a little dispute. Okay, Washington, look. Can't get it now. I don't know, I see. She got the old this case. And here, Satinka. And here, she got the water settlement. I wrote this only hope you go. I asked him, and yeah, we now. Although she was a I asked him and catch it. But you need to go away. They are this. Thank you.
First of all, I'm taking the very fact that my little brother is sponsoring this legislation. I'm taking that to mean he's supporting this legislation. It's not merely for a discussion, he's supporting it. Which I must say I am very, very disappointed with. Because Mr. Speaker, you, by our vote, represent the council. And by our vote, spoke loud and clear last week to me on this issue. And we voted down 2109. So as much as I tried to separate the water settlement from the bill, to me it's the one and the same. So when I vote on this in the negative tomorrow, I want you to know I'm also voting no confidence in both of you, Mr. Speaker and Mr. Attorney General. And you're both my little brothers. Now, and these are the reasons why. Besides the fact that the council spoke, you mentioned that we have no rights. It's very unfortunate that you feel that way, because I have aboriginal rights. Your own grandma and grandparents before us lived here a long time. In time immemorial, that applies tomorrow. And the right of our future people. And that's not for sale. That's not for us to deal with. And then he said, in here, we will have unlimited use of water, according to the agreement. But presently, without this agreement, we have unlimited use of water. So why do we need this agreement? Then you said, NGS, as the owner, have a right to continue. Owner of what? The land, the water? And of course, my colleague over there said, federal government is not acting as our trustee. And we know why they're not acting as our trustee, especially when it comes to NGS. Because they have ownership, they hold shares or whatever of APS, NGS. That is why. So, avocado, my colleagues. Tz'edet akhahila. Ch'edayo ahlaku. Adoshanai, Nashadan Kichiyaj, delegate people. I Eshamatin Karinjahasti and Hayat Eha. Bagi, Ijan Kodobe Ketni Zanti, Washington, I not easy, ye easy, not toss. It's on here that is the Dian, he can't be Kajet on here don't need. Is a Yohod Nide at Lacha Benesh in Washington. Hana Ahwe Mihiyata Jile. Kaya Benina, so it's a dodge home, you know, as you find this there's no cannot tie. Eya Han Sokashin Ashoya and the Has and the Hot Leto Hadanet Anna Hobinina Akinata. Ako enada chitebe ana. Kahosh ready Kahosh ikede iki. Although our Attorney General says we only have 2 options, I believe there is a 3rd option. And that 3rd option, or actually I believe there's a 4th option. The 3rd option is to sit back at the table and renegotiate. Renegotiate. That's the 3rd option. The 4th option is give it to the people and let them vote for it. We represent the people, and I hear the people. I hear their plea for us to vote this down. The 3 chapters I represent voted against this. So I'm not afraid to stand up for what they asked me to do. That's to vote this down, both the bill and the settlement. As much as I want water for the people in that area, as much as I want water to be brought to cornfields where my in-laws resides, I still have to think what is the best thing for our people. Not just now, but 50 years from now, 100 years from now. I will continue to say that. I will continue to say that. So maybe it was a funny thought in my mind. I thought, well, presently everybody says, yeah, Supreme Court will rule against us. Yeah. Well, you know what? Supreme Court are dying off. Maybe the next group will be more favorable to us. So let's hang in there with this, with our claim in court. I believe the international will step up and help us at some point too. I really believe that. This to the outside world is a human rights issue. Todo joya. Kitako joya of the Jordan. Listen. And finally, by the way, why is the federal government still asleep? Why aren't they right now without an agreement delivering water to every home? That's in the Treaty of 1868. I always tell my colleagues, I read that every night. So, it's in there already. We don't need an adverse agreement, a controversial agreement, a promise we all know they will not keep.
Thank you. As I read this, forgive me, but I just got this package today too. But I found page 94, 96. I guess they're just all over. So if you do look through it, you'll find it. On the waivers, I notice in the waiver group that we even reach into other states. Why is that necessary? And I agree with Delegate Benali, there is a third option. The third option is to restrict. There are some good and some bad in this one. There just appears to be a little bit more bad stuff in here. And so, why can't we go back to the table? The other party should be understanding of that. Because what's interesting is Senator Kyle had the option of rejecting the 2008. And so at that time, Navajo Nation agreed to it. I voted for that. One of the main reasons I voted for it is that it included the Arizona Waterline Project. And so I was willing to balance everything and to say that we're going to get at least $800 million, you know, for the Arizona Waterline Project, the Western Waterline Project, that we'd be willing to go for that. And some chapter officials looked me in the eye and said, if we're going to get that, then maybe we should go ahead and allow that. But Senator Kyle said that it was too costly and also had no confidence in his own abilities to convince his colleagues to get more money. And I mentioned this to Senator Kyle at the time we met in Cuba City. And at the end, if I had more time, I was going to tell him that you seem to have no confidence in your ability to persuade your fellow colleagues at the U.S. Senate, and I seem to be the only one that has confidence in your ability. You know, I was going to tell him that at the end, but of course, you know, that didn't happen. But that's my point, is that Senator Kyle had the option of rejecting that one, and he should have ran with that one. And then at that time, allow us to try to push that through. So, you know, in this case, they're back at the table. See, they rejected the first one, and they're back at the table. And so if we reject this one, why can't we be allowed the privilege of going back to the table again? And I think it would be not fair of those other parties to allow the Navajo Nation that privilege. So I think on the waiver, and based on what you said, Mr. AG, that if you studied where the basin line is for the Little Colorado River, then the waiver should only be limited to that region. We should only waive water rights claim, if we're going to accept this, to that boundary of the Little Colorado River Basin. We should not be going into New Mexico. But yet that was allowed in this case. It seems to only be fair to do that. I don't know what the rationale is to be so expansive in our waivers. You know, we should just limit to the Little Colorado River Basin, and that's it. Because we're only talking about the Little Colorado River. And so I wanted to mention that also, if we're going to go back to the table. If we're going to score something big, and saying that we got something big in this settlement, it should be Arizona waiving its immunity so that we can sue them over the upper and the lower Colorado River.
Yes.
And if, you know, what is Arizona afraid of? See, what happened is the bad U.S. Supreme Court, who has no respect for Indian water rights and Indian rights, in the Seminole case, took away the right of Indian tribe to sue the state. They did not listen to all the treaties and the U.S. Constitution. This is the U.S. Supreme Court. You know, when they did that in the Seminole Court case, saying that that was a casino decision, now our own lawyers are using that to say that we cannot sue the state of Arizona. So the only way we could do it is for the state of Arizona to waive its immunity. So what are they afraid of? What's the state of Arizona afraid of? waive your immunity, let's go to court on the Little Colorado, or the Lower Colorado River and the Upper Colorado River claims. Let's duke it out. And then, then we can say that we've scored something big with this one. But in this case, the state of Arizona does not waive its immunity. But they've done the reverse. They make us waive claims in New Mexico. The other interesting too is, and if you go to the provision regarding on page 86, where it says satisfaction of water rights and other benefits, we're not only waiving rights to water rights, but we're also waiving rights to water quality. And so it says that here that all the benefits realized by the nation shall be in complete and full satisfaction of all claims of the Navajo Nation and the United States for water rights and injury to water rights and injury to water quality. That scares me. Because if there's bad water now, during the time of this litigation, we can't raise it. We waived the right to water quality. And what does that have to do with water rights? And I don't think we should be agreeing to something like that. So, and then at page 95, this has never come up before, that only the Hopi tribes and the Navajo tribes are giving up rights under this settlement. But there's a provision in here that says that the little bitty southern Paiute tribes still have full claims. And so why is it that a little bitty southern Paiute tribe can still have full claim and Navajo Nation cannot? And that's right at the clause on page 95. Is it because they are going to file something afterwards and then all of a sudden they're getting something big down the road? So that also, and then finally on the Navajo Nation versus Department of Interior claim, I believe it's at page 88, that we are dismissing with prejudice the first, the second, the third, the fourth, and the fifth claim for relief. The only thing that's being dismissed without prejudice, meaning we can refile it, is the sixth claim for relief. So we're dismissing about 85% of our claims against the Department of Interior. And only 15% we're reserving the right to refile it. But that's against Department of Interior, and again, if we're going to do that, the United States government, as our so-called trustee, should step up and say, we're going to sue the state of Arizona on your behalf for the Upper Colorado River claim and the Lower Colorado River claim. Then if we have such a language in here, then it's worth it. See, but we have a bad trustee called the United States of America. They're not acting as a trustee. And so they're doing us in. And they're going to do this Navajo Nation in, I think, if we allow this. So I think it's very important to have settlement talks. I think we should go back to the table and work something out. And then I think maybe in our legislation we could say that the United States government should allow us to go to the United Nations and air our grievance on how we're being treated by the United States and also by the state of Arizona. We are indigenous to this land. The United States is not indigenous. The state of Arizona is not indigenous. And yet they seem to have the upper full hand. Not because they're smarter, but because they have a bigger gun, they claim. and because they have a drone. So I don't know if there's a drone flying around out there with my name on it. You know, and I need to call Barack Obama and say, hey man, don't give the authorization, I'm a poor citizen. That's just raising these questions. And so, and we pray that there's no drone out there with Catherine Benali's name on it.
Bring it on.
Thank you, Mr. Chair.
Members of the committee, resource. Let me say this, each and every one of you, I have served with you for a number of years. And we have shown respect for each other by means of bringing legislations. This is the very reason why I chose to bring this to the council. That's not the way for the council to get on each other's case, personal case. I always stand on that, and I believe in this. Through the years, I practiced that.
Mr. Speaker, I'm running the show here. Mr. Speaker, I don't think it was personal.
So, Mr. Vice, I had a chance. Time was allowed to Madam Chair to provide that response, and I wish to have the same amount of time. And Joe, to say a little confidence should not. So with that, I'm standing on that very clear. As for myself, you all know I'm not aggressive. I never say anything that to hurt my dog. So with that, this particular legislation settlement, our staff made it in Kashish, as mentioned. The state and all of the parties involved, and they important get someone said, hey, let's get out of this court. Let's talk things over. I think that's our basic rules. And that's what happened. It's up to you. We have to make a decision on this settlement. All this is going on. Let's stop this. Let's make a decision for the people. The options are provided. It's good the options are provided. That's what we're looking for. We're looking for option. If there's an answer to it, let's get that to that option as an answer to this settlement. And that's what we're here for. Thank you.
I'm not backing down on what I said earlier. Because the choice for an alternative was in your hands, both of you, to let. When the council voted to approve my legislation to oppose 2109, if there was respect for the council, la points in the don't lay up with his ball. Hasha Kajo Hadi Afi Hajo Dantini. Chocolate Avant his case. But your sponsorship and moving forward is an affront to me, an affront to the council's decision. So, Akoko, Edito, one of you, Cho, Dila Opiat, Kasha Kajoki Kahi, Jordani, Adok Jo Hundred Atas, Tatas, Highland Opiat, would have been the third option to share with Alban's case. Jean wrote down Igizan because I was a baby to stop with the home just shish it up with a big nonsense. That's how I feel. So that amounts to me a disrespect for the councils, a disrespect for the people. That's how I understand it. And I, for one, won't allow for that. And that's why I said what I do. So, if it's about discussion, beyond that, it's not all you want needs to not
Again, let me say this. This legislation requires the council's action. And I feel it needs the council's action. It needs the council's action for it to make a decision. There are people out there that supports this legislation. And of course, oppose it. So we gotta let them know that the council has taken action. And that, I would say, when we talk about the legislation,
Madam Chair, members of the committee, I hope my words were kind, except to the United States. But I somewhat agree with Delegate Benali. When we first learned of this, the Resource Committee gave instructions to the Attorney General asking that there be communication to Senator Kyle that we are very troubled with the inclusion of NGS, that please reconsider the inclusion of it. As our legal officers, we did that. Later on, we found out that no communication was done to Senator Kyle. Not only as a counsel, but as a client. We've asked, at that time respectfully, we've asked for that to be done. See, this is where our employees do not wish to carry out our instructions, and seems to have, forgive me if I affront you, but seems to have a rogue attitude. We don't need to do that. See, if for some ethical or legal reason that they chose not to, that should have been communicated back to this committee. Apply no such letter was necessary. But that didn't happen. And when that doesn't happen, then we take it as disrespect. And I think that's what, and then on the 2109 decision, and it's a question too, is that, has a letter been sent by the President or by your office, Mr. Speaker, to Senator Kyle, saying that a committee of the whole of the Navajo Nation Council has voted unanimously against Senate Bill 2109. And then asking him to reconsider going forward with 2109, and that it be substituted by much Navajo Nation friendly legislation, because Navajo-Hopi has rejected it. See, if there was no communication on that to Senator Kyle, then I would venture to say, who dropped the ball? Why wasn't that done? Because we got to communicate these almost instantaneously, as soon as decisions are made. See, when the president did not send that, and I would be willing to bet that he didn't send it, then the president dropped the ball on behalf of Navajo people. Once we have to make a decision, it's got to be communicated to DC. Otherwise, people are assuming or making the assumption in DC that we're just dragging our foot, or we don't mean what we say. See, that hurts Navajo people when that happens. I got a chance to participate in some of the water rights forum. My understanding of it is, when it came to Navajo-Hopi, it was Delegate Bates and the Water Rights Commission were there. The instructions was to the Water Rights Commission to go out there and tell the Navajo people about the settlement. The president was not in the council chamber. The instruction was not to the president's office. It was to the Water Rights Commission. So I went home thinking that we did good, and that instructions was given to Water Rights Commission to go forth and tell the Navajo people. Next thing I knew, I saw a press release saying that the president is going to do the forums. So I gave him the benefit of the doubt. Said, okay, good. Water Rights Commission and the president's office is going to hold these things together. In my opinion, they did it wrong. When you have such heavy police force showing up, you know, and it just sets the agenda. It just sets the format. And that's what turned off the Navajo people right off the bat. I've asked in Tuba City to please refrain from doing that or scale it back. Nobody in the president's staff said, he is right. Let's figure out a different way to provide for security. What I've suggested was have the police officers be in the next room, but don't have them be out there whining down every Navajo elder. And to use the word of Ray Birchman, a former delegate, when we went to the Oak Spring, he said that I was afraid to go into my own chapter house. And it says a lot to me. We are scaring Navajo people from going into their chapter house to discuss a complicated subject like this. And that means, and we should admit that we did wrong. We shouldn't be doing that. In 2008, when we did the water rights thing, we did it without heavy police force. And the Navajo people were cordial. We've had some good discussions. But see, we seem, as leaders of Navajo Nation, we seem not to know how to deal with Navajo people. And it really bothers me. I've said, you know, let's bring in all the adversaries, the water rights activists that are adversary to the settlement. And let's sit down with them. What is it that's really gnawing at them? The Department of Justice and others shrugged off my suggestion and said, no. I've asked the Water Rights Commission to reassume control, and they decided not to. And I think what the Water Rights Commission was saying is, the hell with Sosie's suggestion. That's how I took it. So reassume control and let's do this more in a CAF fashion. And let's respect Navajo people and not come in with a big police force. I finally went to the final forum at 40 fines. And it just got worse. And that's where, you know, I myself, personally myself, was suspected of carrying a weapon. And so they wanted me down. Good thing I wasn't wearing a silver bolo tie. Otherwise they would have drawn guns probably. No, this is the same thing we did, I don't remember when Navajo Times released a new photo, this was in the 21st Council, that I didn't even know, that we had snipers on the rocks. You know, and I was saying that probably when I came out of the chamber door, I probably was in their gun sight. And the sniper was probably thinking, should I take the shot or not? And blame it on accident. We were never advised of those sniper forces on the rocks in Window Rock. This is how we're beginning to manage our discussion these days. See, you as a leader, Mr. Speaker, and we as leaders need to reassess this. How do we communicate with Navajo people? I understand, yes, we need to make a decision on this. But there are some things I think that are worthy, I'm hoping, that we pointed out. The RDC has been complaining about, and Witherspoon, the White Witherspoon has been complaining about the inclusion of 50,000 acre feet for NGS. We are agreeing that they will continue to have that. See, on the one hand, we tell Navajo people, no, we're not setting the Colorado River. But that's a lie. Look at page 94, NGS water provision. It says in there that we are going to agree to the allocation of $50,000 out of the Upper Colorado River Compact. We are affecting the Colorado River. See, but on the other hand, we tell Navajo people, no, this is not about the big Colorado River. See, our adversaries are sneaking in provisions like this and forcing us to agree to it, when we should be saying, this has nothing to do with the big Colorado River. Let's keep those provisions out. And you, the state of Arizona, if you want to talk about the Colorado River, waive your immunity. Then let's litigate, and then we'll talk about the Colorado River. But here, they found a different way to do it. And that is to sneak in provisions like this. And so I really believe that as leaders, we need to look out for this on behalf of Navajo people. So we cannot allow them to sneak in provisions like this. Let's limit it to the LCR basin area. If we're going to waive rights to that, it's with respect to that. You know, in litigation, you only talk about the area that you are fighting over. See, the state of Arizona and all these other parties, the cities are forcing us to go out here and waive rights out here when the LCR basin is defined. So I think when we go back to the table, and I don't know how do we go forward with renegotiation too. I think some of the leaders from some members of this committee needs to be involved because of the way this whole thing happened. We need to do it in a different way, or even from the Speaker's office, you know, even from the President, that we need to be there now from here on, because when we totally gave it to our lawyers, this is what they brought back. So Madam Chair, Mr. Vice Chair, yeah, and I don't know when we're going to take the vote, but I have to say I have to vote no on this. And then I'm not saying no to negotiations. I think negotiations need to occur. But we need to send a message back that we need to renegotiate. Thank you, Mr. Chair.
There's a declaration that I'm missing out of the President's office. When we met with him at Noslini Agency Conference, he said that there's going to be 7 meetings going to be held, and he's going to listen to the people. Whatever the people says, I'm gonna listen to the people, whatever they say, I'm gonna take that position. Okay, but the other one, not settled now, it's me, then. So, I'm not sure what is done. That is a hibernation. And I see all the advertisements being pushed. Washington, up. Washington, cheap. Then he vetoes the feral horses. And then he on the chapter, he on the mother. When did he decide to listen to the people? To the chapter? Okay, I should not study. I made a comment about a comma. Hope I didn't call you a comma. Okay, I'm telling you. What would be the easiest to these? This is all about you. I'm not going to come to this comment, not there's a lot that's been said about some covered. I want to say money.
Proceed and vote. Call for the question. Committee members, any others? Delegate Apachito.
Even though this legislation is put down here, it's going to continue.
All in favor? Raise your hand. All opposed? Raise your hand. 1, 2, 3, 4, 5. 5 opposed, 0 in favor. 0 in favor, 5 opposed.